Hello and welcome everyone to our webinar When Franchises End, How to Protect Your Brand and Avoid Disputes. My name is Gemma. I am a practice leader in LegalVision's dispute and litigation team. With me today is my co-host Cameron, who is a senior lawyer in our franchising team. Before we begin the webinar, there's a couple of quick housekeeping items. You'll receive a copy of the recording and slides into your email after the webinar. You can submit your questions in the Q&A box and we will answer them at the end. And please complete the feedback survey after the webinar. You should also be seeing a poll question popping up shortly on your screens. We'd love to know what your biggest concern is when ending a franchise relationship, whether it's to fill a skills gap within. Oh, sorry, there's a pop-up on my screen. It should be whether a franchisee is continuing to use the brand after termination, complying with the franchising code, protecting IP and confidential information, whether it's managing customer and supplier relationships, or you're not sure, you're just here to learn today. And we will just give you some time to put through those answers. So moving on to the next slide. By viewing this webinar, you're eligible to receive a complimentary consultation with LegalVision to discuss how we can help your business. To claim it, leave your contact details in the survey that appears when the webinar ends, or contact us via our website. So moving on to the topics we'll be discussing today. So they're set out here on the agenda. And our first topic that we're going to get started with is the importance of intellectual property protection. And I'm going to hand you over to Cameron.
Thank you very much, Gemma, for that introduction, and welcome everybody. I believe that IP protection will be on the top of everyone's minds as we go through this webinar today. So I wanted to start by talking a little bit about what is common intellectual property or IP in a franchise agreement. So I've put together a bit of a summary slide that identifies some of the key IP used in a franchise agreement. Don't know if we're having some technical difficulties, but the slide will catch up. I'll get started. So obviously there can be differences in the IP that you use depending on the industry that you're in, but some common IP that appears in franchising are trademarks, which are used to protect your brand names, logos, and slogans. You'll also have copyright over written materials, such as your operations manual, any proprietary process documents, such as training materials. You may also have registered designs and patents, and this could be over products or equipment or technology, even software and coding. And then finally, you'll also have your confidential information, which could cover trade secrets, business plans, commercial expansion or market analyses, and obviously methodologies and important business data. Now, in this presentation, the term confidential information and IP can sometimes be used interchangeably because the definitions in a franchise agreement will often cross over. So just know when we're talking about IP, we're talking very comprehensively about what is valuable to your network and to franchisees. The reason why we spend so much time talking about IP is because a franchise agreement is a license agreement where you grant the franchisee a right to use that IP. So the core license of the franchise agreement is what's really important. It's what draws franchisees to your network. And this is why IP is a valuable asset that is sometimes held by a franchisor or a separate company, and the rights about it are really clear. So why are we concerned with protecting IP? Well, the biggest concern that a lot of franchisors have is that former franchisees will continue to use the IP without permission. And there are some potential impacts to a franchise network that are unique compared to an independent brand. So obviously there could be a competitive disadvantage if the new franchisee or another business knows and has access to your IP that you are saying is a unique proposition to our network. There can be a dilution of your brand name if they're using your trademarks or slogans. And this can also cause reputational risk if the services or products are not delivered to the same standard, and even confusion amongst consumers. Another concern, which is quite unique to franchisors, is the impact it has on its committed and compliant franchisees. I mean, if they're sticking with the operations manual and using IP correctly, and they see a former franchisee going rogue and not complying, that can be quite discouraging from them. Now, when we talk about IP protection, there are sort of two aspects we talk about. One is prevention of disclosure, and one is legal action. I'm going to talk a little bit more about the prevention and protection because preventing unauthorized disclosure is much better than trying to remedy the situation afterwards. And even though we're talking about franchise relationships ending, we're not just talking about termination for breach or misconduct, or even the immediate or with notice terminations under the code. We're really talking about all kinds of terminations: abandonment, expiration of terms, and even transfers of franchise to another franchisee. So just to know, we're trying to cover all aspects of when the franchise relationship ends. So jumping into the protection strategies, first things first, as a franchisor, if you have important branding or logos, you need to protect it with trademarks. At a very high level, you might want to use a combination of word-based trademarks or logo-based trademarks or composite marks, which have both pictures and words. And you want to make sure that these trademarks are sufficiently distinctive so they can be registered and then enforceable. With copyright, on the other hand, you don't have to do anything to protect it. Registration is not necessary in Australia, and protection automatically applies, even if you don't have the little copyright symbol on a document. Bear in mind that copyright doesn't protect everything, and it only protects the expression of an idea, not the idea itself. So for example, the actual content in terms of the wording, the layout, how it's presented in your operations manual and your processes, and those methodologies that you've set out, that specific outline can be protected. But the ideas behind the methodologies itself, or the actual delivery of a service or product, not protectable. So make sure that you do understand what is actually protected or not, and use the copyright symbol where you can. But importantly, have a think about where your important copyright is. Maybe it's on a website, maybe it's on internal documents, and you can even track the versions and timeline for the creations of these documents. And then finally, sitting alongside trademarks is business name registrations, which are often overlooked by a lot of franchisors. But this can be really important because this is the business name that a franchisee will trade under, and they will almost always register the business name via the Australian Business Register to their own ABN. Now, what's really important is that you as a franchisor have the authority to manage this business name, or a right to take this business name back if the franchise relationship ends. And you might do this one of two ways. You might have a specific authority to liaise with ASIC in the ABR, or you might have a power of attorney in the franchise agreement, or you might have both. And to help ensure that you are aware of when franchisees continue to use business names or similar names, you can even implement domain monitoring services to keep an eye out for other businesses that might be encroaching on your brand using similar or deceptive names. In terms of managing your own internal resources, another protection strategy that we often talk to franchisors about is having a register of what your important intellectual property is. This is not mandatory, but if you're a bigger organization with a lot of different IP and you have teams based around areas, you might want to consider having an IP register. At a heart, it is a list of what the important IP is, who holds it, who has access to it, when it was made by who, and even things like the current version it's on and the version it was recently updated, if you want to go into a lot of detail. What a useful feature of IP registers can be is adding comments or a column for who has access to this document and if that access is still present or revoked. So for example, for trade secrets or business plans, you might want to keep these limited to a highly close-knitted group of the franchise or head office. Or you might keep this limited to certain franchisees only in terms of the directors, but not any of the managers or employees of those franchise businesses. It's really up to you. Likewise, there might be documents that you're happy to provide access to employees. For example, the operations manual, even though it goes to the franchisee and their directors or principals, the responsible managers may need to know who of those documents so they can operate the business in accordance with the manuals. But if you're doing documents online, which a lot of franchisors do, you can manage this access even more strictly. If you have an online portal or an intranet or some kind of system where franchisees have to log in, you can manage those logins with administrative access. You can see what employees or managers of the franchise businesses both have access and when they have access the online internet. And you can even set, as I mentioned earlier, different hierarchies of control. So not everyone can access the core data of a franchise business, but the standard policies and procedures that you need employed throughout the network, they can be accessed by franchisees and their staff equally. Now, what's useful about having this control over access is the data for when access occurs, including any downloads or unauthorized access. It allows you to get a bit of a timeline for when there might have been a breach of your IP rights. Additionally, when the franchise ends, it's much easier to disable or change the password for someone's login if you no longer want them to be accessing the system. And it's important to do regular security audits to test the system and make sure that no one has been hacked, especially in today's day and age, to help protect the integrity of this IP. Obviously, you can't protect against anything, and everything, and screenshots can still happen, but what you're hoping for is any red flags, such as a large amount of downloads or unusual accesses from different IP addresses, mobile device. These can be some red flags to warn you that your IP may be at risk. And then even though we're in a very digital age, physical documents still are used today and can be important, but they have their own inherent types of risks. And even though this should be common sense, making sure that you have secure document storage, and if there's any documents that you don't want to be shared and you don't have a legal obligation to keep, and this might be due to financial or taxation records, or if it's in relation to potential legal proceedings, you may want to look into shredding either on-site or off-site to ensure that this kind of confidential information or discussions, even talking notes, don't get accidentally shared. And again, someone with a phone can take a picture of notes and that can be shared around, and that could potentially be quite detrimental, especially if you're having discussions of a commercially sensitive nature, such as expansion plans or even discussions about how to manage a franchise network. And this can actually come up in legal proceedings. So make sure you do seek some advice about what documents you need to keep and should keep as a matter of good business practice, and what documents you can actually remove, especially if they have been marked as confidential, which is obviously a good warning to everyone if they're sneaking when they shouldn't be. And one of my favorite topics to talk about as a lawyer is how to prepare your contracts, particularly your franchise agreement. IP protection should be at the heart of the franchise agreement and an area which features prominently in terms of the contract between the franchisor and the franchisee. Some of the key things that we've mentioned on the slide that you need to ensure your IP provisions cover is who actually owns the IP, and not just the original trademarks and processes and systems that are given to the franchisee at the start, but also any improvements to the IP that are made, especially where franchisees have contributed. You want to make sure that the IP can change over time, but you continue to have ownership over existing and new IP. You also want to make sure that use of the IP by franchisees' employees isn't going to affect your continuing ownership and your rights to take control of that IP back. And you also want to ensure that the use of it is limited to the genuine purpose of the franchise business. So if it does happen to fall outside or be used for another purpose, you have some rights, which Gemma will talk about a little bit later on. And at the start of the presentation, I talked about the kind of crossover between confidential information and IP. There is a bit of a line here. My general guidance is don't define intellectual property or confidential information too broad, especially if it might cover something that is publicly available. You want to ensure that these provisions have the right balance to maximize their enforceability. Speaking of confidentiality, this works in parallel with IP. And even though, as I said, there will be some crossover, the kind of confidentiality provisions we put in there are positive obligations to protect and preserve confidential information that is shared, discussed, or disclosed in the course of a franchise relationship. Now, this might be specific and very strict confidentiality provisions in the franchise agreement, or it could be part of a separate confidentiality and restraint deed that goes alongside the franchise agreement. And this can be used to cover key personnel, such as nominated managers or business managers, but also shareholders and guarantors who may not necessarily be directors of the franchisee. So having a think about who else is going to have access to the data will help you determine what kind of scope of protection is reasonably necessary. And in terms of the people who may or not are necessarily parties to the contract, franchisee employees are usually a contentious issue in terms of how a franchisor can try and protect the confidential information IP against them. Now, the best way is to ensure that your franchisees have suitable confidentiality provisions in their own employment agreements. And you might have this as a provision of the franchise agreement, or you might even give them a template section and say, this needs to be in all of your employment agreements. And if you do that, make sure you actually conduct audits and check to make sure the franchisees are putting this in their employment contracts and having them signed. And an example provision might say that the franchisor can enforce this provision on behalf of the franchisee who's the employee, and this could be really relevant if you have to take legal action. And then one thing that always comes up in terms of protecting IP is the use of restraints of trade or restrictive covenants, things like non-solicitation clauses. Without going into too much detail, because Gemma will discuss a little bit more how these work in practice, the purpose of these is to grant protection to franchisors in addition, or sometimes in place of, restrictions of IP or confidential information, especially where the goodwill of a franchise needs to be protected. At a high level, restraints of trades aren't always enforceable, and the franchisor needs to prove that there is a legitimate reason for the restraint of trade to be enforced, and that doesn't go further than necessary. And these can consider things like public policy, statute, prior experience or skills, or the nature of the franchise relationship. One thing that is unique to franchisors is that you need to consider the enforceability of restraints where there has been a non-extension or non-renewal of the franchise agreement. And the code, both the old code and the current code, which came out last year, have provisions that say that restraints are not enforceable in certain circumstances if there was no genuine compensation for goodwill that was given to a franchisee who wanted to renew or extend but was refused. And there are additional penalties in the code. A recent webinar on the changes to the code went into this in a little bit more detail. So if you want more information on that, go check out that webinar or send us a message afterwards. And then finally, whenever you are ending a franchise relationship, make sure your obligations on termination are clearly set out in the franchise agreement, particularly restrictions on use of IP, any events that need to are conditional for a transfer to happen, as well as having clear timelines for what needs to be part of a surrender when the franchise relationship ends. And as part of this, there will be certain obligations that continue, like those intellectual property and confidential information sections of the contract that should survive termination or expiration. And you should be quite explicit that these clauses will continue to ensure that termination of the franchise agreement doesn't allow someone to use your IP once it finishes. So in terms of some practical examples, once you've got your contract set up, the key obligations you should take when a franchise comes to an end is ensure that the franchisee is aware of their obligations to destroy or return any confidential information or IP or data that they might have access to. And you might do this tangibly with physical documents or might be digitally, as I mentioned earlier, with revoking access. You may also want them to hand over email logins or passwords, or if you have the domain control, you could potentially do this yourself. And this can even extend to social media accounts, which are managed by the franchisees that you might want to be taking over if you're going to assume the business. From a stand for physical premises, obviously there's signage and other branding such as menus or directories that may need to be removed, as well as physical materials that franchisees might have, so merchandise that will need to be returned ideally, or could even be sold to another franchisee or to the franchisor if you have that option to purchase those assets. Any transfer of the lease or license and giving physical keys, a very important part of taking back control of the brand and the goodwill for a premises, can also be important, as well as return or cancellation of the business name. Just be mindful that cancelling a business name can prevent its re-registration for 6 months, so transfer is usually easier. And then finally, because money is important to the continued health of a network, ensuring that debts to the franchisor and any other trade creditors of the franchisee, especially important suppliers, are paid either by termination or within a reasonable time frame from termination. And this might be something that you negotiate with the franchisee as part of any purchase of equipment or stock. So now that you've set out the key obligations, actually going through the offboarding procedures to prevent the unauthorized use of IP is a very important practical process to take. And I always recommend to franchisors to have a very clear offboarding procedure that you use consistently and improve with time based on feedback and learnings from various offboardings. You want to clearly outline the steps that a franchisee needs to comply with. It's already in the franchise agreement, it should be, but it always helps having another document, such as an end of franchise checklist, to go alongside it. But beyond this, you want to ensure that there's adequate communication between you and the franchisee. And this might be some meetings, if there is still an amicable relationship, about what will happen and when. For example, if there are debts, if there are stock, if there are ongoing orders, you might have a conversation for a handover period. Or if there's a new franchisee coming in, you might want to get a little bit more involved to make sure that it's a very smooth transition from one exiting franchisee to the incoming franchisee. But if you have a closure of a franchise business, especially a physical premises, you want to ensure that you do have some inspections that happen before termination and then around the time termination happens to check that they have actually complied. For example, it might take them a few weeks to remove the signage because they need the landlord's approval, but you want to ensure that you go and make sure that this is actually being done and that there is a line of communication with the holder of the premises. And I also do say to franchisors, be realistic with timelines. A lot of drafting requires people to do things immediately, but you want to show a little bit of concessions to understand when things need to happen, but make sure that you do put timelines. If you leave obligations too open-ended, it can affect your ability to enforce these from a legal perspective. And then finally, ensure you are actually compliant with your obligations in the code. If there is a termination that's happening because of a breach or misconduct of a franchisee that allows you to terminate the franchise agreement, make sure you've done this properly. This might be following the breach provisions in the franchise agreement or the code, potentially even following the dispute resolution provisions if there has been a dispute. And this will help avoid any potential issues coming up down the line. What you can also do is trying to keep an extra eye on what happens to the franchisee staff, even sometimes before termination happens or an agreement comes to an end. If there's any high turnover of staff and they start working for another business or another company, this might actually give an indication that there could be a potential breach by the franchisee that's about to happen, or abandonment, which Gemma is about to go into shortly. And in addition to the domain monitoring services I mentioned earlier, you can even set up some searches on ASIC to notify you about changes to a company. But at the end of the day, if you see something, get advice and take prompt action, and this will be the best way to protect your brand and help avoid disputes from happening. So that's all from me on the prevention front. Gemma's now going to talk about how franchises can deal with the abandonment of a franchise relationship, in particular to protect your IP. Over to you, Gemma.
Thanks, Cameron. That was very interesting. The next few topics that we're going to discuss are more dispute related. That's because it's helpful to have an understanding of some of the types of disputes that arise and what that dispute process can look like when considering preventative actions that can be taken to protect your brand and your franchise. So one of the first ones that we're going to look at is abandonment of a relationship by a franchisee. So this is a common end to the franchise relationship that will often result in a dispute. It typically occurs when a franchisee decides to cease operations without proper termination of the franchise agreement. So that might be by simply closing the doors and walking away, or they might continue operating but changes the brand name, signage of the business and takes that business with them. So obviously in these circumstances, it can cause significant legal and financial implications for both parties. Some of the financial impacts on a franchisor can include lost royalties, brand damage, market share loss, wasted resources, future expansion limitations, loss of marketing fees and other ongoing payments under the franchise agreement, and then obviously loss of value IP and confidential information. So what do you do when this situation arises? So before you think about taking any kind of formal legal action, you want to be looking at pre-litigation steps. So obviously have a review of your franchise agreement, your dispute resolution and abandonment terms. The code allows for a right in most franchise agreements to terminate with notice for abandonment of a franchise relationship. You want to send a termination letter off the back of that and set out the termination obligations and mention the dispute. This is all assuming that you've already made contact with the franchisee to confirm that it is in fact an abandonment and that no other action can be taken. So you're looking at that situation of an abandonment. You want to quantify any debt owed and any loss from the breach of contract. You want to think about sending out a formal letter of demand. It might be for invoices outstanding, debts owing, and other obligations that they won't have complied with because of the abandonment. They haven't followed the post-termination obligations. So for example, return of IP. You want to have a think about negotiations and alternative dispute resolution at this point, sorry, because even if under the code it's not applicable, it's always going to be a sort of a less expensive and quicker resolution than looking at formal litigation. So we always say you should try and negotiate first. You've got options there for mediation, conciliation, or arbitration. You might have heard those terms. They might be in your franchise agreements. We're not going into that in detail for this webinar, but it's certainly something that you can come and talk to us about. So moving on, you've gone through all the alternative dispute resolution processes, and really you're only left with looking at litigation. So whether or not you decide to litigate, it really will be a decision for the franchisor based on commercial necessity. So you might want to think about how far through the franchise relationship you are, what your actual loss is, what benefits you're going to get from commencing proceedings, and really having a commercial look at the costs in related to proceedings. So there's a couple of different options in relation to litigation. So you might just want to go for a debt recovery option. You can just file a standard statement of claim with the court seeking payment of your invoices. There are some other actions that you can take. You might have heard about statutory demands against companies or bankruptcy proceedings against individuals, but these are really only for undisputed debts. So if there's any dispute that has arisen, which typically it will do if it's, some sort of breach termination, you might only just want to be looking at the standard debt recovery actions. And even once you get a judgment, you've then got to think about how to enforce that. So you might be looking at garnishee orders. So that's an order over someone's wages, or seizure and sale of assets. Typically, with franchise disputes that arise, we see that franchisors are looking for breach of contract remedies, which are obviously damages for breach and loss arising from that termination. Another option is account of profits, and that's something we're going to discuss a bit further on. Otherwise, you might be looking at orders for specific performance, which again is if franchisees have not complied with their post-termination obligations. You might want to enforce your rights to have IP returned and confidential information, etc. Okay, so as I've said, I'm just going to have a quick look at account of profits. So this is an equitable remedy for profits wrongfully earned by your franchisee. It's commonly seen in trademark misuse, so the continued use of trademark after termination. You can also use it in relation to operating a competing business and breach of non-compete clauses, or otherwise misuse of confidential information or trade secrets. A franchisor must prove the breach and the resulting profits. So once the breach has been established, the court can order a full disclosure of profits. The franchisee must provide detailed financial records, and then the court decides whether that profit amount is linked to that breach. So it can be quite a complex and time-consuming process. It is an alternative to damages, so both can't be claimed, and you need to consider whether the franchisee's profits are going to exceed your losses when considering this type of remedy. So that's just looking at that specific remedy. Moving on, I just want to talk quickly about mitigation of loss. So this is an obligation on all franchisors to minimise the impact of a breach of a wrongful act or wrongful termination before even thinking about commencing any kind of litigation. So if you don't comply with this obligation, it can reduce the amount of damages that are recoverable. And complying with it actually shows the court that you as the franchisor have acted reasonably and in accordance with the obligations to act in good faith. It can also reduce the overall financial impact on your franchise system, and quick action can help with market presence and brand protection. So all of these are actually beneficial to the franchisor as well, and again, might help you make those commercial decisions about what action to take following these steps. So just moving on to the next slide, we've set out a list here of examples of mitigation of loss strategies. So that might be negotiating with the franchisee, negotiating with suppliers in relation to existing contracts, and having negotiations with the landlord in relation to rent and lease terms. There's a few different things there that you might want to consider in relation to finding new franchisees, potentially running a store as a corporate store and appointing a management team, or resource reallocation, so redirecting your customers. That will obviously depend on the location of any store, for example, and whether or not those customers can be redirected locally, reassigning staff, and reallocating equipment or inventory. So this slide, this next one, mitigation of loss, is just setting out how to document those efforts. So you've gone to those efforts, and this is all again about keeping records of your marketing materials, operational records, and other things that you've done to mitigate that. And that can be used as evidence in relation to court proceedings down the track. And again, can help you convince the court that you've done everything reasonably necessary and that you've still suffered a loss as a result of the franchisee's actions. The last topic that and the next topic that I'm going to talk about is in relation to avoiding counterclaims. So this is important because even if you file proceedings for something that the franchisee has wrongfully done, franchisees may still file counterclaims in relation to responses in relation to your action. And this can necessarily make the case that you've brought more complex and time-consuming. It's a potential for set-off arises, so there might be an award of damages for both parties, and then it means less of a payout to the franchisor. It can involve cost implications. Obviously, it can change the court timetable with new evidence and additional witnesses. That can all increase your legal spend and your legal costs. A lot of the counterclaim allegations that we see coming through from franchisees can include the list there on the slide. It includes misleading and deceptive conduct, non-compliance under the code, breach of contract, inadequate training or support, and the breach of the good faith obligations. So in order to avoid some of these counterclaims from happening, there's some ongoing, there's some preventative methods that you can take. Oh, yep, just waiting for the slides to catch up. So preventative measures from the outset. So this is before this franchisee has even become a franchisee. So ensure that all your marketing is accurate and all claims can be substantiated. It's really important not to sort of state things in your marketing that's then not followed on in practice, as that will give rise to misleading and deceptive conduct claims. You need to carefully consider and make a record of all representations you or any of your staff members or agents make. This is because the risk starts from the very first interaction with a prospective franchisee, and it's really important to remember that. So it might be a discussion 3 months before they even sign up to the franchise agreement. You might have made some comments to them that they then try and later say that they relied on in entering into the agreement. So again, it's really important to document all your interactions, encourage them to take independent advice and do their research, obviously comply with your disclosure obligations. And as Cam said, there is obviously a well-drafted franchise agreement will have some terms in there to offer some protection. The next slide there's just got some ongoing measures for you to consider during your franchise, which includes, regular performance reviews and feedback, making sure you enforce standards consistently across your franchise network, obviously complying with the code, offer adequate training and support. So make sure if you're saying that you're giving a certain amount of training, this is actually implemented in practice. That'll help you obviously meet your good faith obligations. And transparency is something to think about for your individual franchise network. So that might be in relation to financial practices, marketing activities, and supplier arrangements. That's often a problem, when people are looking at the fees, but they don't really understand what they're being paid for. Obviously, you've got to consider that in the context of your own specific franchise, whether that'd be appropriate. And just very quickly, because we're short on time, I'm very quickly going to look at restraints of trade and injunctions. So in terms of restraints of trade, these can include non-compete and non-solicitation restraints. And as Cameron's already noted, these are not automatically enforceable. So what does the court look at when thinking whether these can be enforced? Reasonableness is a big ticket. So it is in relation to the duration of the restraint, the geographical area covered, and the scope of activities prohibited. So this really is what we're talking about when we're talking about a well-drafted franchise agreement. It really needs to consider these and not just be a broad scope, because that is not going to help you when you're looking at a dispute down the track. You need to make sure it's covering your legitimate business interests. So that can be confidential information and trade secrets, customer connections and goodwill, and integrity of the franchise system. There are also public interest factors to consider. So impact on market competition, effect on earning a living of the franchisee and the restraints that you've put on them, and economic and social implications. So again, obviously there's a note there about drafting franchise agreements, which we've already touched on. So before thinking about taking injunction proceeding steps, you want to, again, be thinking about pre-litigation steps. So there's always pre-litigation steps before you're considering any court action. So for these types of claims, you want to act quickly to limit the damage arising to your franchise from a breach. You want to gather the evidence, as much evidence as you can in relation to the breach. You always want to send a cease and desist letter initially. This will set out the terms of the breach. What conduct do you want to rectify the same? You might have demands in there for example, for a return of IP, etc. And sometimes we find that that can resolve matters without having to go the cost of filing proceedings. But again, even if not, it's something to put before the court to show the steps that you've reasonably taken. You obviously want to consider alternative dispute resolution terms. You want to weigh the costs and risks of an injunction against the benefits. And, oh, slides moved. So what is an actual injunction? It is actually a court order requiring specific action or refraining from certain conduct. It's used to prevent harm or maintain the status quo until a full hearing. Interim orders can be sought urgently, but then final orders will be sought after a full hearing. You've obviously got to take steps to convince the court to grant these orders urgently. So things that the court will look at is you need to demonstrate that there's a prima facie case. That is, that the case has merit on the evidence that you've put before the court. You need to convince the court that damages are not an adequate remedy. So if the matter is left to run and this person's taken all of your trade secrets and your IP, they're essentially going to destroy your franchise, as an example. So damages are not really going to help you if that's just left as the status quo. You need to stop that action straight away. So that's why these orders can be granted urgently. And you need to prove that on the balance of convenience that the order should be granted. So there are risks and benefits to injunctions. Obviously, the risks may be uncommercial. There's cost risks. There's risks that the orders aren't made or they aren't made in the way that you've sought. The benefits are, again, it can be a quick remedy to stop competitive activities. It can stop the use of confidential information, protect market share and goodwill. It can act as a deterrent to further violations, not just from a particular franchisee, but your network as a whole. It can prevent long-term damage to your brand or business model. It will maintain the status quo until a full hearing of the matter is heard. And it can prevent irreparable harm. So injunctions can also be considered when looking at trademark infringement, passing off, and breach of confidence. In addition to the specific order of relief sought from the court in terms of the action to be stopped, you also be seeking damages or an account of profits, which we've already discussed, and that would be through the main court proceedings that would then follow on from any urgent orders made. So every dispute turns on its own facts and circumstances, but we would encourage you to consider the information and preventative measures that we've discussed today in the context of your own franchises. We hope that you found the topics covered today informative. As I said, you're going to get a copy of these slides to take away and have a think about. I'm now going to hand you back over to Cameron.
Thank you very much, Gemma, for that. And we've also actually put together a link here to the how to end a franchise fact sheet that will summarize some of the key aspects that the franchisors need to think about both approaching the end of the franchise relationship from a legal compliance perspective, but also a practical perspective, considering the commercial matters and other considerations of unwinding the business relationship. So there's also an event coming up in next week, actually, which is about supported independent living, a success blueprint for mastering the legal and financial landscape. So if you find your businesses in this industry, definitely go and check that out. And we're going to go through your questions shortly. So if you haven't already, please submit them through the Q&A channel. So the way that we support franchisors and our clients generally is through our LegalVision membership. Now, the benefit of membership is you get access to our in-house 150 plus specialist lawyers that cover broad areas from disputes to franchising, commercial, corporate, trademarks, employment, you name it. And we're here to cover all of your legal needs. It's essentially like having an in-house counsel that is an expert in everything for the fraction of the cost. So we can assist you with unlimited document drafting and reviewing and compliance updates. And for franchisors, as we've got the new code coming in now, plus further changes happening in November and your regular annual disclosure document updates, having a look at what you've got in your franchise agreements to make sure they're enforceable and you're not going to be breached the code has never been more important than now. It also includes unlimited legal advice consultations to raise questions about topics, both managing network, dealing with suppliers, dealing with financial questions and practical considerations to help develop strategy to avoid disputes and better protect your IP. And of course, with Protect IP, we'll do your trademark registrations and assistance with breach notices and even termination notices for franchises to make sure that you are taking prompt action when you need to be. So the benefit of membership, you don't have to worry about the costs again because it's fixed cost that goes monthly. And we cover all your business as usual legal needs work, plus provide extra support when you need it. And if you are an in-house counsel, we do have separate products or a desk extension to help with your high volume business as usual legal tasks. So if you are interested in finding out membership or desk extension, make sure you request a free consultation by completing the survey at the end of the webinar. Right, so we're going to go through some of the questions that you've submitted, but beforehand, we'll just actually run through the results of the poll. So the poll was, we'd love to know what your biggest concern was when ending a franchise relationship. And the top two results were managing customer-supplier relationships and just being here to learn, which is really good to know. And that protecting IP and confidential information, complying with the franchising code, and the franchise and continuous brand were the lowest results. And I think that's very interesting, especially when, as Gemma was mentioning, the customer and supplier relationships, you might have the legal rights to take over these customers, but thinking very practically about what negative side effects could occur with your business if you go in and disrupt the customer relationships. And this will inform whether you want to take damages, account of profits, or specific injunctions against franchisees. So we've got actually a question here, which is a very, very relevant question. So thank you so much for submitting it. It's which strategies do franchisors often use to remove high-performing but toxic franchisees? For example, a franchisee may be at the end of their second term. They may be disengaged as they believe they know more than the franchise or support team. Well, I've actually seen this happen in my years of practice. And I guess there are kind of two ways I would approach this. One, you look at, I guess, from a compliance perspective, you need to make sure that if you are concerned about their performance in terms of their conduct, any breach notices that you issue are valid and are supported by requirements in the operations manual. So, for example, you have a behavior and communications policy. You want to make sure that these are introduced fairly with reasonable notice and are done in good faith, i.e. don't make a policy to single out a specific franchisee, make a policy that ensures a standard, and then take steps such as issuing a warning letter or having in-person meetings before you take the steps of threatening termination. And if you do want to go so as far as threatening to terminate a high-performing franchisee, be mindful that they may fight back, especially if the business has done well, have good reasons to keep it. So ensure any termination is in accordance with the code and it's not done improperly, because this could prevent the termination from happening, but also could result in a counterclaim that Gemma was mentioning and potential penalties, fines for breaching the code. But if you do have a franchisee coming to the end of their second term, you can also look at the renewal rights or any extensions, and especially seeing if their renewal is automatic or if it's at your discretion, and making sure, again, you're acting in good faith and in accordance with the contract here. And as I mentioned earlier in the presentation, whenever you're looking at the end of a contract that's not extended or renewed, the franchisee did want to extend or renew, make sure you have a look at the contract into context of clause 23 of the old code or section 42 of the new code to see if the restraints of trades can be enforceable if you're not giving damages or the damages were non-nominal or not meaningful to compensate them for goodwill. But as an alternative to terminating, trying to get them out of the system, you can even try and bring them back closer into the fold. And this might be involving them in a franchise advisory council by relying on their expertise and their knowledge and saying, hey, I actually want you to help us to help manage the network and give improvements as a franchise representative. And they could take special roles in developing and testing new products or services. They might take extra leadership training and support with other franchisees, or you might give them incentives. This could be a sliding scale that provides compliance to reduce royalty fees to, again, help encourage them to invest and grow the business. But at the end of the day, if they're not playing well with others, it might be a matter of sitting down and having a very serious conversation. We've got another question here, which we'll run briefly because we're running a bit over time, which is what can be done to ensure that business IP confidential information are not leaked by employees upon termination? Very good question, and Gemma and I have been involved in this for franchisors in the past. So I guess from a contract preparation perspective, make sure that you obviously have all those restrictions and confidentiality provisions going in your franchise agreement and in the franchisee's employees' contracts, and check those contracts. But you can also identify any high-risk employees who think might be likely to leave and take access to that IP, and make sure you obtain third-party advice about enforceability. And as Gemma briefly touched upon in her presentation, you're also looking to other avenues such as breach of confidence, where an employee has breached their confidentiality obligations, or the franchisee has been involved in an inducement of that breach or vice versa, because that can also help you take actions. And I know we did have a few more questions, but unfortunately, that's all we've got time for today. So if you do want to get in touch with us or you have other things you want to run by us, make sure you submit your details in the survey for 48 hours after the end of the webinar. You can claim a free complimentary legal consultation where we can run through some of your business needs and discuss how membership can help. So thank you very much for your time. While this was a free webinar, we do value your feedback. So if you have any feedback, please also complete the 30-second survey at the end. Thank you so much for joining us, and Gemma and I wish you good luck with protecting your brand and managing the end of relationships effectively.
Thank you for joining us.